Hey everyone, welcome to Crime and Court. This is another episode of the Commonwealth versus Karen Reed Trial 2.0, and we are discussing this is the final actually motions in limine episode that we're going to be doing, and these we're going to be going over the procedural matters. So let's get to it. Please hit that like button if you don't mind. And I will shrink myself so we can get started. I have a bunch of motions that we're going to go through, and they're all different kinds of topics. So let's just get started with the Commonwealth's motions. So, up first, as you probably already have heard, there is a motion for a protective order. This was approved already by Beverly Cannoni. There was no ability for the defense to oppose this, but here we are with a gag order on both the defense and both the defense and the prosecution. However, I don't like that she just went and approved it without even having the defense have any say in it. That's what happened. So the Commonwealth respectfully moves pursuant to Massachusetts Rules of Criminal Procedure Rule 14A6 for this honorable court, to establish a protective order restricting the public dissemination of all communications to be provided to the defendant on March 10th, 2025, detailed in the Commonwealth's Notice of Discovery 61. This order is necessary to effectuate the well-established privacy and safety interest of witnesses and the victims' families. Furthermore, certain materials being provided as discovery in this case may be evidence in an unrelated pending criminal case. So they're talking about Turtle Boy and his unrelated. No, that's not unrelated. Furthermore, certain materials being provided as discovery in this case may be evidence in an unrelated pending criminal case. Michael Morrissey? Or not Michael Morrissey, Michael Proctor? I don't know. Who's in a criminal case other than Turtle Boy? But that I would say that Turtle Boy's case is related. Anywho, I don't know. So the issue of a protective order is the inherent authority of the issuing court, and protective orders serve to shield litigants and third parties from unwarranted disclosures and, as a practical matter, to facilitate the discovery necessary for a trial. Commonwealth versus Fremont. Commonwealth agrees that this protective order to be set without prejudice. So they submitted this motion, sorry, not an affidavit, but they submitted this motion and she signed and approved it the same day with no feedback or ability for the defense to say anything. I think that's wrong. I don't like the way that I feel like just the way that they're playing feels dirty to me, does it not? I mean, I just feel like they're playing dirty. And I think they have some more tricks up their sleeves before the start of the trial begins. And I don't like it. It makes me uneasy. All right, so the Commonwealth's motion in limine to allow in-court identification. So they want to be able to identify Karen Reed, I believe, in court. So the Commonwealth moves in limine to allow an in-court identification of the defendant, yes, in accordance with the rule announced on December 17th, 2014. So they want witnesses to be able to, like, on the stand, be like, yes, that's who I saw that night. 4 cases tried after that date, they're saying. Okay. In Creighton, the court ruled that where an eyewitness, the court ruled that where an eyewitness did not participate before trial in an identification procedure, good reason for an in-court identification must first be shown. We have a footnote here that says the court based the new rule on common law practices of fairness and did not address the subject under state constitutional principles. So in Collins, the court ruled that this rule also applies where an eyewitness to a crime has not made an unequivocal positive identification of the defendant before trial. While the court did not categorically circumscribe when good reason might exist, the court provided the following two examples of good reason. One, the eyewitness was already familiar with the defendant before the commission of the crime, and two, the witness is an arresting officer who was an eyewitness to the crime, and the identification would merely confirm that the defendant is the person who was arrested for the crime. So basically, they want people like John McCabe, Carrie Roberts, and all the law enforcement and EMTs to point to her and be like, she did it. I heard her say, I hit him, I hit him, I hit him. And that's all the evidence you need. Case closed. But that is not all the evidence we need. We need actual evidence, and the evidence does not show that Karen Reed hit John O'Keefe with her car. And if you follow the evidence, it looks more like he was beaten inside that house. But I'm not saying, I'm just saying. So the court explained that in these circumstances, the witness would not be identifying the defendant based solely on his or her memory of witnessing the defendant at the time of the crime. While there are no eyewitnesses to the crime itself, witnesses observed the defendant close in time to the crime and in the subsequent aftermath and recovery of the victim's body. The circumstances here meet the good reason standard, as in Creighton, there was no out of court identification procedure conducted prior to the trial. The Commonwealth intends to lay a foundation that the witnesses were familiar with the defendant prior to January 9th, or 29th, 2022, the date the defendant is alleged to have murdered John O'Keefe. Obviously, they were out at the bar, and all the Waterfall bar and CF McCarthy bar people are going to come up to the stand again because they're pretty much all on the list except for the Colakeithuses, because the Colakeithuses don't help the state's case. They have nice things to say about Karen. So they weren't they were also missing from the trial one Commonwealth witness list to the trial two witness list. They were the Colakeithuses. And well, we'll get to that. So the Colakeithuses and Sergeant Nicholas Barros, who is the Dighton officer who testified that Karen's car her taillight was cracked, not completely damaged. So he's missing too. So we'll get to that because we are going to read through the witness list following this motion. So the Commonwealth's witnesses include individuals who were friendly with the defendant and knew her through her relationship with the victim. This is not a case where a particular witness is identifying the defendant based solely upon his or her memory of witnessing the defendant around the time of the crime. As the court stated in Creighton, under these circumstances, where witnesses knew the defendant prior to the crime, there is little risk of misidentification arising from the in court show up. So basically, there's little risk by identifying somebody in court if they know the person. So, like a Jennifer McCabe or a Carrie Roberts, who is familiar with Karen Reed and has had multiple conversations with her, has spoken with her, familiar with her. So, um, those are probably going to be the people that we've got identifying them, all right, or identifying her. So further, the facts support that there is good reason for the police officers and first responders who interacted with the defense on scene at the hospital and at subsequent interviews to be permitted to make an in-court identification. So again, they want people from the hospital, first responders who interacted with her, police officers. Sorry, I'm highlighting really crookedly here. I'm kind of off-centered. So they want to bring in police, first responders, anyone who was there at the scene that knew her prior also. All right, so for these reasons, the Commonwealth's motion in limine uh, to admit in court identification should be allowed. This motion, I didn't mean to have, I meant it to be separately, but it's on the same file, but that's okay. Doesn't matter. Okay, so this motion is so we're going to get to the witness list after this. The Commonwealth's motion in limine of intent to obtain Corey records of potential jurors. Prior to swearing in the jury, the Commonwealth moves in limine for the opportunity to inquire into the criminal records of jurors to determine whether they are qualified to serve. Outer time limit for the exercise of preemptory challenges is before the jurors are sworn. Challenges for cause to be made before the juror is sworn to try the case. So, inquiring into the criminal records of jurors in a criminal case for the purposes of determining their qualifications to serve and their impartiality fits squarely within the criminal justice duties of prosecutors and is permitted by the Corey statute. So, this is basically like a background search. They're doing a background search. Excuse me, I'm gonna shift my crooked here. So they're doing a background search for the jurors. Totally lost my train of thought. And they're requesting this. They did this last time. They did this before they had the same motion last time. Like I said again in previous motion in limine videos, the prosecution basically is re-prosecuting the same case. I don't see any real big differences so far. Everything, like all the motions, all their pretrial motions and their motions in limine have been the same. So they're not really trying to come at the case completely differently, I guess, if that makes any sense. They haven't done, I mean, Hank's done some different things, but he hasn't done anything regarding litigating the case completely differently than Lolly, even though he's just much worse to listen to. All right, so the mistrial occurred as a result of three jurors failing to disclose their extensive criminal histories. So if you don't disclose your criminal histories, or you're caught lying on your jury questionnaire, and your Corey comes back saying something other than what you said, you're probably going to get uh, they're probably not going to use you, is what I'm saying. But if you don't do a Corey and then it comes out later, then you have a mistrial. So you need to do the Corey ahead of time, is basically, I guess, what that's trying to get at. Further, the Commonwealth is allowed to inquire into the criminal histories of jurors to determine a juror's ability to be impartial. A juror who purposefully conceals their criminal history cannot be found to be impartial or able to follow the court's instruction. Despite a lengthy voir dire that focused largely on jurors' attitudes toward law enforcement, the jurors' silence about their criminal histories were found to be purposeful. So even if you try to get on a jury, or not try, but you're being voir dired for a jury and you lie about your criminal history, they're going to find out at some point. And they're going to find out. So it's not good to lie. But they're saying that it was done intentionally or on purpose, maybe with the purpose of trying to mislead court officers, I guess. I don't know. So before the jury is sworn, the Commonwealth intends to check the criminal histories of all 16 prospective jurors. The Commonwealth's right to examine a juror's criminal records is not a radical one, and the Commonwealth will produce the Corey records to defense counsel. If the prosecutor checks the juror's criminal records, which ordinarily should be done at the start of a trial, the information must be shared immediately with defense counsel. So, okay, so they're going to share it with defense counsel if there's something wrong, or Oh, if the prosecutor does check their criminal records, then they have to share it with the defense. Okay, good. So judges encouraged to exercise discretion to order Corey records of selected jurors before they are sworn, where procedure is not unduly burdensome or time consuming. So basically, let us do these Corey searches because it'll save us from possible mistrials, and also it can eliminate people from the jury who don't belong on it. So, I mean, it makes sense, and it's not a bad thing to do for the jurors, the potential jurors. All right. Now we're at the Commonwealth's prospective witness list. Now comes the Commonwealth in the above captioned manner and provides the following list of prospective witnesses who may be called to testify in the case. Commonwealth moves to partially exempt from Mass R. Crim P 14, effective March 1st, 2025, that requires the Commonwealth to produce the names, addresses, dates of birth, and known contact information of the Commonwealth's prospective witnesses other than law enforcement witnesses. The Commonwealth asserts that given the ongoing harassment of witnesses, threats to witnesses' personal safety, and the highly publicized nature of this case, there is a special circumstance warranting non-disclosure of the witnesses' addresses, contact information, and date of birth. So they are not redacting, but uh, refraining from listing it. The Commonwealth further moves to be exempt from providing law enforcement officers business email addresses. Oh, I would love to email some of those people. I'd love nothing more to email them all day. No, just kidding. But that would be something. They would get emails for sure if emails and stuff were posted on here. And their addresses, business addresses, are attached. All right, so the Commonwealth's list. First, we have for civilian witnesses Brian Albert Jr., Caitlin Albert, Chris Albert, Colin Albert, Julie Albert, Nicole Albert. That's a lot of Alberts. As you know, those are all of our suspects. um, and Brian Higgins, which we haven't gone to yet. All right, so Stephen Bernstein is the keeper of records. I don't remember who he was from last time, if he was someone. Caitlin Boudreau, not sure who that is. Michael Camerano was a friend of John's, and they were drinking that night at CF McCarthy's. Katie is his wife. Richard D'Antano is the person that was driving the car with um, Ryan Nagel and Ryan Nagel's ex-girlfriend Heather Maxim. He drove the car to 34 Fairview. He was right behind Karen. It was his car that was there at the scene. All right, next up is Keeper of Records Gene DeMulis. Not sure who that is. Brian Higgins, Louis Jutras. I think he was like was he not part of the CF, the Public Works guy, isn't he? I can't remember now. There are so many witnesses, and I definitely think that their witness list grew this time around. We have the niece and nephew of John. We've got Hayden Carney, which is just insane. They're never going to call him. And if they do, they're going to regret it because Aiden is so well spoken and he is going to love to go to battle with Hank. So that would be just a huge mistake on Hank's part. Sarah Levinson was there in 34 Fairview Road that night. Heather Maxon, like I said, she was in the F-150 or whatever the truck that Richard Dantano was driving. That was Sarah Levinson, Heather Maxon, Jennifer Matthew McCabe. We know who they are. Of course, they were going to testify. We have more keepers of record. A Bridget Meehan. I don't know who all these keepers of records are. Where did they come from? Julie Nagel was inside the house. Ryan Nagel came to pick her up. Paul O'Keefe is the brother of John O'Keefe. Aaron O'Keefe is the missing in action spouse of Paul O'Keefe. I don't mean to laugh, but Aaron O'Keefe, let me backtrack. Aiden Carney wrote an article about Paul O'Keefe and busted him. I didn't get into it because it's drama, but Paul O'Keefe was basically sexting a woman who reached out to him, basically saying, like, I feel bad for you because your brother passed and, I lost a sibling too. And she started, she reached out to him for comfort. They ended up having a months long flirtatious texty relationship, and many of the texts from him were very inappropriate, very disgusting. I don't even want to repeat them. But yeah, so since that article was published, Aaron O'Keefe has not been in court at any of the pretrial hearings since. So I don't think she's standing in solidarity with Paul. And I think it would be amazing if she turned sides and started testifying for Karen Reed and in her defense. But I don't think that's going to happen, but it would be nice. Also, look at this. Nathan and William Reed. William, the father of Karen Reed, and Nathan, the brother of Karen Reed, are on the witness list. Like, really? They weren't even there. They didn't even talk to her. Like, I don't understand why they're on the witness list. I think it's just to threaten Karen to make her feel less stable, less like her support system is not there as much, like to try to break them up or something. I don't know. I think that's what the point. Kurt Roberts is the husband of Carrie Roberts. I believe he was out drinking that night with them. I can't remember. I think so. Otherwise, why would he be called? I'm pretty sure he was out drinking. I think they were all out drinking at Waterfall. Steve Scanlon, which that's an interesting one because Steve Scanlon is rumored to have visited David Unetti's office a couple days after Karen Reed was arrested, saying, "Your client didn't do this. She was definitely framed, and you need to look at the homeowner and the individuals that were there that night." And he may have implicated some names. And then he got scared and didn't want to testify or write an affidavit or anything like that. I believe he has a daughter that's friends with all of the kids in that house. Like like that were there that night with Brian Albert Jr. or whatever. So it's even rumored that they might have been there that night or knew something that night. So I don't know how he knew, and that's what he needs to answer to. So how did he know that? Who told him that? Where did he get that information? And is it credible? So I think he really does need to come and testify. So why he's there for the Commonwealth, I don't know, because I think he's only going to help the defense. We've got the Aruba sisters, Laura and Marietta Sullivan. I'm sure they will say what an awful person Karen Reed is and how much she sucks again. Rebecca Trayers, I am not sure who this is. This might be a new civilian witness, so that would be interesting. Michael Trotta, he's the Canton PD guy, Department of Works guy, I think. No, I can't remember. Gretchen Voss, who happily gave over her notes. Actually, no, she did fight turning over her notes. I will give her that. She fought hard to not turn over her notes, but in the end, she had to give them over to the prosecution. All right, so here are the Canton Fire Department witnesses. We've got Jason Becker, Anthony Flamati, Matthew Kelly, Katie McLaughlin, Timothy Nuttall, Francis Walsh, Danley Whitley, and Gregory Woodbury. I believe those are all the same people as last time. Katie McLaughlin is friends with uh, what's her what's her face? Caitlin Albert? Was it Caitlin Albert? I think. Now I can't remember. Um, my brain is fried. I've done a lot of recordings in the past few days trying to get caught up with these motions in Limine, so I apologize if I'm not on my game. All right, so up next is Paul. This is the Canton PD. Paul D. Giampietro. Remember, he is the retired sergeant who had all the files downloaded on his computer all of a sudden out of nowhere. We're just learning and just found out recently. So he's coming to testify about that. Paul Gallagher, he's retired now, but he did testify in the last trial. Sean Good, Michael Lank, all of these people are friends with the Alberts. Stephen Mullaney, Chief Helena Rafferty. I don't believe she was on the witness last time, but she really needs to be because if you recall, Chief Berkowitz was the chief at the time, but Helena was the deputy chief. And Berkowitz, old Berkey, who was out on medical leave, came back and started investigating this case while he was on medical leave. But since she's the deputy chief, she was like the second in command, so she's in charge. So she was technically in charge of this investigation. So it all comes down to her, really. And so you can't blame it all on Berkowitz and his death. And, now that he's dead, just blame it all on Berkey. No, you can't do that because Helena was the deputy chief of the Canton Police Department at the time. So she still is responsible. We also have Ray Charles, I'm sorry, Charles Ray, who is written backwards. Charles Ray, who is, I remember these names, they all testified. Stephen Seraph testified. Brian Wanless, he is the one, I believe, that actually removed the housing, the taillight housing from the vehicle. I think that's what he's going to testify to. We have, I don't know who this is, but we have a Needham Police Department Sergeant Brian Gallerini. Needham. I don't know what like how Needham is even in relation to this case. Then we have Massachusetts. Is that where Karen lived? Needham, perhaps. That's where her home was. And I don't know. Maybe she has a record because remember they tried to pull in, they asked for records of uh, the defendant, previous motor vehicle records and things. So I don't know, maybe she had a ticket or something from previously in her neighborhood. I have no idea. All right, so maybe she sneezed wrong on someone and they arrested her there. I have no idea. Massachusetts is a little strange with their rules. So out of the Massachusetts State Police, we have Evan Brent. I don't remember that name from before. We have a Yuri Buchanan. I remember that name. We have a Sergeant Zachary Clark. I remember him. Nicholas Garino, who can't find text messages, like 32,000 of them between Matthew Farwell and Sandra Birchmore. Kevin O'Hara, Joseph Paul. So Trooper Joseph Paul is returning, perhaps, if they call him, but he's on their list. Michael Proctor is on the list. Will they actually have the cojones to call Michael Proctor? I don't think so, but we'll see. And then Brian Tully, of course, Brian Tully. And oh wait, there's more to this. Hold on. I only have the first 4 pages. Shoot, hold on. Okay, we're good. All right, so here are the expert witnesses now. We've got Shannon Burgess, which that is the guy that he was a forensic guy that was saying that the how's long to die in cold. No. what was it? He was the guy that confused the bits and bytes, and somebody, Karen's expert, Matthew Erickson, like totally made a fool of him. He made the bits and bytes uh, mistake in his affidavit. Then we have Colleen Crawford, who was in control of the video surveillance footage and didn't hand it over to Matthew Erickson when he came to the Canton Police Department. Then we have James Crosby, who I told you he's the dog bite expert or dog bite. I'm sorry, he's not a dog bite expert. He is a dog trainer, and they're bringing him on as a dog bite expert, which is not the same thing at all. They are appealing that, so we will read through that in the next episode of the not appealing, but they're asking Judge Canoni to reconsider her decision on allowing him to come in because he's not qualified. And she's already said that only medical experts can uh, testify to the causation of medical injuries. And how can he do that when he's a canine aggression behavioral, dog behavioralist? He's a dog trainer. He helps calm down aggressive dogs. Robert Gilman is going to testify that the ground, he's a meteorologist, but he's going to testify that the ground was hard as a rock, which has nothing to do with his expertise. We've got Jessica Hyde. We know her. We know of her. Gary Fowler, MD from Good Samaritan. I don't remember if he testified or not. I don't recall seeing that name. Andrew Klain from Aperture LLC. Not sure what Aperture is. Mike Meroli, Justin Rice, MD, I recall Justin Rice from last time, but I don't remember when he testified to. Irene Scortibello, she's the medical examiner, the official chief medical examiner who examined John O'Keefe's body. Renee Stonebridge, I believe she assisted in that autopsy. Judson Welcher, this is a new one. We have, okay, so this aperture, that's where I saw that. So this aperture, this Andrew Klain and Judson Welcher, they are or the I saw on the docket, I haven't seen the actual paperwork come in, but there is a new motion from the defense asking to strike Judson's testimony. So I don't know what he's testifying to. I haven't seen the motion, but that's in the works. Ian Whiffen, who just wants to sell his product. Isaac Wolf, who is a neurologist, which has nothing to do with anything and shouldn't even be testifying, and they contested his testimony as well. So as you can see, it's pretty much the same. And we're going to there's a few more people that they're calling. They're not calling Sergeant Barros, like I said. They're not calling the Kolakithases. Those are the only two that I really noticed. Oh, Tristan Morris, the boyfriend of Caitlin Albert, is not going to be testifying either. So, yeah, I don't know. We shall see. That will be interesting. All right, let's move on to this next filing. The Commonwealth's motion in limine for sequestration order and for relief from that order for family members of the victim. So basically, they want to sequester everybody. And I think that's why William and Nathan are on the list, including Turtle Boy and others that I don't think they even plan to call. But they want to sequester people. So the Commonwealth moves for an order of sequestration of all witnesses expected to testify at trial. The Commonwealth further requests that this court allow the following potential witnesses to be accepted from the sequestration order. So victim's brother Paul O'Keefe, Aaron O'Keefe, the nieces and the niece and nephew, Peggy O'Keefe, the mother. They are allowing William Reed, Janet Reed, and Nathan Reed to be in the courtroom. Decisions concerning the sequestration of witnesses are one within the judge's discretion. This court has the discretion to allow the family and friends of the victim to observe the trial after the Commonwealth's case in chief has been completed. Judge's decision to allow victim's mother and grandmother to remain in courtroom to observe entire trial but to not exempt from sequestration order defendant's mother one dis- blah, within his discretion. I can't talk. Additionally, the family members of a deceased victim have the right to be present at all court proceedings unless this court determines that their testimony would be materially affected by hearing other testimony. Which witnesses will be called in the Commonwealth's case in chief or rebuttal cannot be reasonably decided pretrial and will depend upon the introduction of evidence and cross examination. Testimony of many of the witnesses will be brief but may not necessarily occur at the beginning of the Commonwealth's case. Other witnesses, including the defendant's family members, are tentative and may not be decided until near the end of the trial. Excluding the defendant's family members who eventually may not be called would be an unfair infringement upon the defendant's support network. If the Commonwealth reserves defendant's family members for rebuttal and the defendant should choose to testify, then the Commonwealth would seek exclusion of the defendant's family member during her testimony. What? If the defendant were If the Commonwealth reserves defendant's family members for rebuttal and the defendant should choose to testify, they want her out. They want them out of the room. If Karen Reed testifies, then William Reed and Nathan Reed need to go, is what they're saying. There is good cause to relieve the above witnesses from the sequestration and impose the limitations suggested. The Commonwealth is not seeking for the witnesses to be relieved from the portion of the sequestration order that bars them from discussing their testimony with witnesses who have not yet testified. This portion of the sequestration order should be strictly enforced. So they can still. Oh, that's where that went. I was looking for that. I got stuck to this. There were so many filings I couldn't remember, or I couldn't keep track of all of them. So, anywho, yeah, they're saying for the foregoing reasons, the Commonwealth's motion should be allowed. Um, I don't know, whatever. At least they're allowing William and Nathan Reed in the courtroom, but they do want to exclude them for some of it, I guess, or try to if she testifies. All right, so let's move on to the defendant's motions. Defendant's motion in limine to allow counsel to state grounds for objections to promote judicial economy and efficiency and to adequately preserve issues. Now comes the defendant, Karen Reed, and respectfully moves this honorable court in limine to allow both parties to briefly and concisely state grounds for their objections in open court during the retrial in this matter in the interest of promoting judicial economy and efficient administration of justice and the preservation of issues. What do you guys think? So Judge Canoni did not allow anybody to state their grounds for objections, obviously, in the first trial. And this is a motion so that they can state grounds because, and here's why. There's a lot of reasons why, but for a judicial economy, efficient administration of justice, and the preservation of the issues so that they can, if they need to, they can appeal and they have the objections on record. So the undersigned counsel would like to note that this is not a request for lengthy speaking objections. Any issues that could be perceived as having an ability to coach a witness while on the stand or potentially bias the jurors with extraneous information will still be dealt with at sidebar. So sidebar conversations, they're saying we can totally, we're cool with those. Counsel is merely requesting the ability to state grounds for their objections. By way of example, rather than simply stating objection, counsel would state objection hearsay or objection calls for speculation, like you're supposed to do when you state your objections. I added that last part. So, as grounds for this motion, Ms. Reed states that the court generally The court's general order that counsel not state grounds for their respective objections before the jury led to extensive discussions at sidebar, which lengthened an already extensive jury trial. Ms. Reed further states that the inability of defense counsel to state grounds for objections could lead to their inability to preserve issues for any necessary appeal. Stating the basis for an objection in a word or two will not cause either side any prejudice. While Ms. Reed acknowledges that generally considerations of judicial economy must yield to the defendant's right to a fair trial, in this instance, it is the defendant making this request. And we have a footnote here that says see Commonwealth versus Sylvester and Commonwealth versus Gaynor. All right, so Massachusetts courts and the rules of criminal procedure have outlined several scenarios that demonstrate the general promotion of an interest in judicial economy and efficiency. For example, the Supreme Judicial Court has noted that joinder under Massachusetts R. Crim P9 may promote the economic adjudication of criminal offenses. I don't know what they're talking about there. All right, so additionally, some of these like quotes, no offense, but they make no sense sometimes when you're not a legal scholar and you don't know where those are coming from. All right, so additionally, the Supreme Judicial Court has condoned the practice of taking motions for mistrial made during closing argument under advisement until after the return of the jury verdict to promote judicial economy and efficiency and to preserve valuable judicial resources by obviating the need for retrial should the jury return a verdict of acquittal. Finally, judicial economy was explicitly cited as a consideration by the Supreme Judicial Court in eliminating the so called power of resurrection in criminal cases, noting there are many rationales for the raise or waive rule, that it is a necessary corollary of our adversary system, that's hard to say, in which issues are framed by the litigants and presented to a court, that fairness to all parties require a litigant to advance his contentions at a time when there is an opportunity to respond to them factually if his opponent chooses to, that the rule promotes efficient trial proceedings, that reversing the error not preserved permits the losing side to second guess its tactical decisions after they do not produce the desired result, and that there is something unseemly about telling the lower court it was wrong when it never was presented with the opportunity to be right. The principal rationale, however, is judicial economy. There are two components to judicial economy. If the losing side can obtain an appellate reversal because of error not objected to, the parties and public are put to the expense of retrial that could have been avoided had an objection been made. And two, if an issue had been raised in the trial court, it could have been resolved there and the parties and public would be spared the expense of an appeal. Related to the now defunct power of resurrection doctrine, the failure of counsel to state grounds has, in at least one instance discovered by undersigned counsel, led to an appellate court holding that counsel had failed to preserve an issue in an unpublished decision. The appeals court of Massachusetts outlined the scenario that could easily recur in this matter absent the allowance of this motion in limine. The key passage from the Cabral Varela opinion reads as follows. The most hotly contested issue at trial was the identity of the shooter. The Commonwealth sought to establish the defendant's identity in part by introducing a security video of the shooting that showed the shooter wearing a white t-shirt and eliciting evidence that that was what the defendant habitually wore. This evidence consisted of testimony to the effect from a percipient witness, Erica Moody, a police officer, Kevin Swan, who was familiar with the defendant, and a police detective, Kevin Dugan, who had participated in the investigation and had viewed the defendant's social media pages. Dugan also authenticated two social media photographs of the defendant wearing white t shirts. The defendant argues on appeal that this was inadmissible habit evidence. Parties dispute the standard of review with respect to the habit testimony. The defendant argues that the issue was preserved and that the standard of review is for prejudicial error. The Commonwealth argues that it was not and that the standard of review is for a substantial risk of a miscarriage of justice. We agree with the Commonwealth. The prosecutor twice asked Swan whether the defendant typically wore any particular type of clothing. Defense counsel objected to the first question without stating his grounds, and the judge sustained as to no foundation. So he didn't state any grounds, but then he was just like sustained as to no foundation? What? I mean, so the judge stated the grounds, apparently. The prosecutor immediately laid a foundation and asked the question a second time. That's garbage. That allowed the prosecution to readjust what they said and how they asked the question. The defense counsel again objected without stating his grounds, and the judge overruled the objection. In these circumstances, it is clear that the overruled objection was based on foundation grounds, which is insufficient to preserve an objection on habit grounds. While defense counsel objected at sidebar shortly before Dugan's testimony, the objection was only to the introduction of the photographs, not Dugan's testimony, and was on cumulativeness grounds, which is also insufficient to preserve the issue for appeal. So the type of objection that there's a whole number of types of objections that a lawyer can say. And there are different phrases that come after the word objection that might not hold up an appeal, or if you are raising an objection for one thing, it's not going to hold up on an appeal for the thing that it's actually for, if that makes sense, like in this case. So this was a really good example where the actual reason for your objection is very important and should very much be included here. Put simply, defense counsel's failure to state grounds for his objection, 1, led to the appeals court to infer the grounds for his objection, and 2, having done so, to determine that the defendant was entitled to a less deferential standard of review to which he would otherwise have been entitled had the correct issue been preserved. Although the court went on to say that even if the court had applied the more deferential prejudicial error standard, which it did not, the court would still have determined that the error did not influence the jury or had but very slight effect. So again, just the wrong type of objection was used. So, more important than the specific facts in the case, however, is the fact that the appeals court agreed with the Commonwealth that because defense counsel had failed to adequately preserve the issue, because he failed to state the correct grounds for the objection, the standard of review on appeal would be the less favorable to the defendant, a substantial miscarriage of justice. Since the ability to state the grounds of objections will both 1, further the interest of the court and the public in judicial economy and the efficient interest of justice, 2, will avoid the possibility of failure by counsel to have the ability to adequately preserve any possible issue on appeal, and 3, would prejudice to neither party. It would cause prejudice to neither party. Ms. Reed respectfully requests that counsel be allowed to state the grounds for objections during the retrial in this matter. And then this was David Yannetti. He filed an affidavit in support of that motion that we just read. So I am an attorney licensed to practice in Massachusetts since December 20, 1989. He gives his information. He was retained to represent Karen Reed in January of 2022. During the first trial in this matter, the court's general order that counsel not state grounds for their respective objections before the jury led to extensive discussions at sidebar, which lengthened an already extensive jury trial. Cognizant of how counsel was appearing to the jury, which was forced to endure multiple and often lengthy sidebar conferences, there were times when it was unclear what the basis for the Commonwealth objection and the court's ruling was. Yet so as not to further aggravate and or annoy the jury, the defense was forced to pick its battles in calling for a sidebar discussion of an evidentiary issue. In this way, our duty to zealously represent our client faced conflicting concerns, preserving the record versus maximizing our credibility before the trial jury. Based on our legal research, I'm sorry if you can hear that. There's like thumping going on, like someone's bass really loud. We have a really obnoxious neighbor sometimes. But so based on the legal research, there is at least one instance wherein defense counsel's failure to state grounds for his objection, one, led the appeals court to infer that the grounds for his objection were what they were, and two, having done so, to determine that the defendant was entitled to a less deferential standard to review than he would have been entitled to the correct issue had the correct issue been preserved. So basically, the objection that was used, there was no grounds. So there was, okay, so someone objected, there were no grounds that were used, and then the appeals court had to infer what kind of grounds they were, um, what they meant. And then by doing so, they basically side more so with the state than they do with the defendant. They give the defendant the lesser of the appealing options for the defendant. They side more so with the state, is what that's saying. So I believe that the same issue could recur in this matter, absent a modified order from this court regarding counsel being able to state the basis for objections briefly and succinctly. Otherwise, if the court maintained its prior ruling on the form of objections during this retrial, we believe that this could infringe upon Ms. Reed's right to a fair trial and any appellate rights she may need to exercise should she need to exercise them. I believe that allowing counsel to state objections would promote judicial economy and the fair adjudication of this trial, as well as avoid any potential appellate issues that counsel were not able to state the grounds for objections without approaching sidebar. I believe there will be little to no prejudice to either party in stating a legal basis for an objection in a word or two in open court. Accordingly, I believe it is in the interest of justice with the honorable court, if the honorable court allows this. So that was his affidavit. I sure hope she does, but again, it's Bev. I mean, that's all I have to say. It's Bev, and we don't know what she's going to do. It doesn't hurt to just say objection irrelevant or objection leading, Plus, it helps the other attorney to know like what it is that they're objecting to so that they can rephrase their question better. It's so stupid that she's done this, that she allowed that no objections. And they're not asking to say speaking objections, which would be like, Your Honor, the defendant didn't do that and blah blah blah. Here's why. That would be a speaking objection, and that's basically you testifying. Um, and that's not what you're supposed to do. Or, Your Honor, that's irrelevant and da 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 da. Here's why it's relevant. You just say objection, irrelevant, sustained, or objection, irrelevant, overruled, and then you move on. And it's just supposed to flow nicely that way. It's not supposed to have all these sidebars. All right, let's move on to the defendant's motion to impound the defendant's motion in limine to prohibit the Norfolk District Attorney and Massachusetts State Police from having juror contact. So you can assume what this is about. We know that there might be some juror intimidation potentially, and that came up in their motion to dismiss for extreme judicial government misconduct, whatever it was. Um, so here is now they're trying to get the DA and the MSP, Massachusetts State Police, from having any contact with the jurors. I'm assuming that's what they're wanting. So now comes the defendant, Karen Reed, and respectfully moves this honorable court for an order impounding the defendant's motion to prohibit the Norfolk District Attorney and Massachusetts State Police from having juror contact because the exhibits supporting the motion, as well as the discussion of those motions, are subject to this court's order of impoundment, specifically the transcript of the June 25th sidebar conference Exhibit A and the text message exchange, which included Lieutenant Fanning and Trooper Proctor. Exhibit B must both be filed under order of impoundment. So there are text messages and things from Lieutenant Fanning, perhaps, and Trooper Proctor. So this motion was impounded. We did not see it, but here is an affidavit in support of that. Again, this is David Yannetti. He says, good cause to file this motion under order of impoundment because this court ordered that both exhibits in support of this motion are subject to orders of impoundment. So we can't reference anything because it's all under orders of impoundment. So therefore, just impound the whole thing and be done with it. So that's what they did. But at least we know that there's something. There might be some substance there to the jury tampering uh, allegations, perhaps. There might be some contact between Proctor and Fanning, maybe, or Fanning and maybe uh, the DA, because why they add the DA's name to here too. But I mean, it should go without saying that you're not supposed to be the DA, the prosecutor, none of you are supposed to be contacting the jurors. But it's sad. It's really sad when you have to put things that are like common sense law in a motion because they're so corrupt in the district that you are um, practicing in, that you have to basically write motions to remind the judge of certain laws. I find it quite I have to laugh or else you cry. I mean, it's depressing, it's infuriating, it's enraging, and I just want Karen Reed to be free, and I want this persecution of her to end, and Turtle Boy's persecution. However, they have dug their heels in so deep at this point, there's no going back. They have done more now to damage their own reputations and their careers by doubling down and not budging on this when it's clear that Karen Reed is innocent and the people that should be in prison are sitting there staring down the jury members to give them the verdict that they wanted. It's outrageous to me, and this is 2025, and this should not be happening. Let me know in the comments below what enrages you the most about this case, because I know there's a lot that you could be enraged about. So let me know. And I will talk to you guys in the next one. Be prepared for a filing with from the defense trying to exclude James Crosby again. So we will go through that. Thanks again for watching. Take care. Bye now.